what else can you patent? The expansion of patentable subject matter into new and more intangible realms has always been met with resistance. Patents involving the use of electricity were condemned 140 years ago, as were biotechnology patents 30 years ago, and, as we just learned, software patents that began 20 years ago. In each case, critics warned that these new kinds of patents would block scientific discovery and innovation. Yet, in each case, after the criteria for each new kind of patentable subject matter were more or less settled, innovation and discovery actually intensified, and their benefits to society multiplied. Recently, the same resistance has been developing towards gene-related patents. These began to be issued in significant numbers after the Supreme Court's 1980 ruling in Diamond v. Jacobardi, which upheld the first patent on a newly created living organism, a bacterium for digesting crude oil in oil spills. Since then, patents have been granted for isolated gene sequences, but only on ones with known functions and not on naturally occurring genes in humans or other organisms. Patents have also been granted for gene sequences used in diagnostic testing and on gene sequences that have been altered to make them more useful in a specific application. In March of 2010, however, a federal district court judge ruled in the case of Myriad Genetics that even isolated DNA is fundamentally the same as naturally occurring DNA and is therefore ineligible for patenting. This ruling was reversed by the U.S. Court of Appeals for the Federal Circuit in July 2011. But then after several back-and-forth rulings in the courts, the Supreme Court on June 13, 2013 finally determined in a unanimous decision that a naturally occurring DNA segment is a product of nature and cannot be patented merely because it has been isolated. This invalidated Myriad's patents on the BRCA1 and BRCA2 genes. The court did rule, however, that the manipulation of a gene to create something not found in nature, such as a strand of synthetically produced complementary DNA or cDNA, could still be eligible for patent protection. All the patents discussed so far, including software and gene patents, are called utility patents. Utility patents are the most common type of patent. They preclude others from making, using, or selling the invention during the term of the patent, which begins on the grant date and ends 20 years from the filing date for an average of 17 to 18 years. But the Patent Act also provides for two other types of patents: plant patents and design patents. Plant patents were first created to protect new species of asexually reproduced plants, mostly flowers. Plant patents are different than the utility patents granted for bioengineered plants used in agriculture. Although the requirements for plant and design patents are substantially the same as those for utility patents, there are some crucial differences. The most important of these is the substitution of a different test for one of the three criteria for patentability discussed in the previous section. Instead of novelty, utility, and non-obviousness, the criteria for plant patentability are novelty, distinctiveness, and non-obviousness. To be patentable, plants must be cultivated rather than found in the wild. The plant patents are granted only to protect a new, distinct, and non-obvious variety of asexually reproduced plant. For example, those grown not with seeds but by grafting, budding, or cutting. A plant need not be useful to qualify for a patent, but it must be distinctive in its color, habit, soil, flavor, productivity, form, or other aspects. Design patents are granted to protect new, original, and non-obvious ornamental designs for articles of manufacture. For example, in 2009 and 2010, Apple was granted patents that covered, among other things, the unique rounded corner design of the iPhone. In 2005, a design patent was issued for the look and feel of the iPad. Design patents can be just as valuable as utility patents, as Apple discovered when a jury awarded it $1 billion in damages against Samsung in August 2012 for the latter's infringement of Apple's utility and design patents. The case is currently on appeal. Like plant patents, design patents also substitute a different test than utility in their requirements for patentability. Instead of the novelty, utility, and non-obvious requirements for utility patents, the criteria for design patents are novelty, ornamentality, and non-obviousness.